Rejection in contract law is a powerful legal concept that can instantly void an offer and end negotiations. Understanding how rejection works is essential for anyone involved in contracts, whether you're buying a home, negotiating a business deal, or simply entering into an agreement. When an offer is made in contract law, the recipient, known as the offeree, has several options. They can accept the offer, reject it, or make a counteroffer. Rejection occurs when the offeree declines an offer that was made to them. This can happen verbally, in writing, or through actions that imply rejection. One of the fundamental principles of contract law is that once an offer is rejected, it becomes void and unenforceable. This means the offeree cannot later change their mind and accept the original offer unless the offeror decides to reissue it. Rejection can take two main forms: express rejection or implied rejection. Express rejection happens when someone clearly states they do not accept an offer, such as saying, "I decline your offer," or sending an email explicitly rejecting the terms. Implied rejection occurs through actions inconsistent with accepting the offer, with the most common example being a counteroffer. A counteroffer is essentially a new offer made in response to an original offer. When you respond to someone's offer by proposing different terms, you are simultaneously rejecting their original offer and creating a new one. For example, if someone offers to sell their car for $20,000 and you respond by offering $18,000, you've made a counteroffer. The legal effect of a counteroffer is significant. It terminates the original offer completely, shifts the roles of the parties, and creates new legal obligations. The original offerer becomes the offeree, and now they have the power to accept, reject, or counter your offer. This back-and-forth exchange is a normal part of contract negotiations. Consider a real estate transaction where a seller offers their home for $250,000. If the buyer responds by offering $240,000, the original offer is void, and a new offer has been introduced. The seller cannot force the buyer to honor the original price, as that offer no longer exists legally. Offers can be terminated in several ways. An offeree can terminate an offer by letting it expire or by rejecting it outright. Almost every offer has an acceptance deadline, and if the offeree does not provide acceptance during this time frame, the offer automatically terminates. If no deadline is specified, the offer will expire after what courts consider a reasonable amount of time. It's important to understand the difference between revocation and rejection. Revocation occurs when the person who made the offer withdraws it before it's accepted. The offerer must communicate the revocation to the offeree before they accept. Rejection, on the other hand, is when the recipient of the offer refuses it, which immediately terminates the offer. A key distinction is that revocation can happen at any time before acceptance, whereas rejection is solely the action of the person receiving the offer. Interestingly, rejection does not take effect until the offerer receives notification of the rejection. This differs from acceptance, which takes effect upon sending the notification under the mailbox rule. This timing difference creates a unique situation. If you reject an offer by mail but then change your mind, you could accept the offer by phone before the rejection letter is received, and your acceptance would take priority. The acceptance would be valid because it was communicated before the rejection was received. The Uniform Commercial Code provides special rules for the rejection of goods. If goods delivered under a contract do not conform to their contractual description, the buyer has the right to reject them. However, the buyer must make their rejection within a reasonable time after delivery and must notify the seller of the rejection. The seller may have the right to cure the defect if the rejection occurs before the performance period expires. Failure to properly notify the seller may result in the buyer being obligated to accept the goods despite their nonconformity. Understanding rejection in contract law is essential for effective negotiations and protecting your legal interests. Whether you're making offers, receiving them, or considering counteroffers, knowing how and when rejection occurs can help you navigate the contract formation process successfully and avoid potential disputes.